Good afternoon. My name is Kris Paxton. I am the Director of Administrative Services. Today we are going to have a City of Siloam Springs Unified Development Code Stakeholders Roundtable. I'm going to go ahead and call this to order. Mayor Nation was going to preside over this. She was unable to attend. So going straight into today's agenda, we will begin with an introduction of our staff and our stakeholders.
Yes, my name is Ben Rhoads. I'm City Senior Planner.
Megan Thomas, current plan.
Randall Clark, Senior Building Inspector.
Clint Garstetter, CK, Civil Engineering.
Gene James, James Surveying.
Jim Caldwell, Caldwell Technical Services.
And we do have one stakeholder that's not currently present that will likely be joining us through the meeting, and that is Ron Holmeyer with Civil Engineering Incorporated. I'm the Director of Administrative Services that is over planning, among other components within the city. The Building Division, Code Enforcement Division, the Planning Division all make up our Community Development Division. So today we're meeting today with stakeholders. Stakeholders are typically individuals or companies or representatives thereof that would represent our development community. Those what we did at the beginning of this project for the Unified Development Code was we identified any individual that represented a client that brought forward a development proposal to the City of Siloam Springs for the previous 2 years, and we sent a notification out to those individuals to complete a stakeholder questionnaire. Out of the individuals that provided feedback throughout the process, we did collect specific comments, some of which were not able to attend today. However, we will be going through some of these comments that we have already been provided, and there will be plenty of opportunity for people to participate. When we get to the portion on the agenda that says final group discussion, I will open the floor for public comment from the general public. That was previously going to be up to Mayor Nation to make that determination. As the ranking staff member present, I will be providing them the opportunity. However, we do have a fixed time to adjourn at 5 p.m. Next up, we have the rules and expectations of the meeting. I will start by reading the rules of order for this meeting. I will preside over the meeting. Stakeholders raise their white paddles to be recognized by myself to speak. I may provide opportunities for the stakeholders and staff to have informal discussions without recognition by the presiding official. The meeting has been made available to the public to attend for transparency. However, this meeting is to allow stakeholders an opportunity to discuss the Unified Development Code. I will strike the next line, which states that there will not be public input unless the mayor determines there is an opportunity during the allotted time. I will be providing that opportunity. Staff is also scheduling an additional town hall for citizens Q&A. There will be a town hall meeting on June the 24th from 5:30 to 6:30 p.m. Stakeholders are asked to keep their comments directed at the topics being discussed. There will be a time after the initial round of comment reviews, which will be open format among the stakeholders. During the open discussion time, please raise your white paddle. You can see those with your names on them next to you. And you would wait to be recognized to present your discussion. Open discussion needs to identify in the UDC where your concern is and how you propose to amend to resolve the issue. This is a workshop to identify where stakeholders are requesting improvements in the proposed Unified Development Code. Discussion is not pertaining to specific requested changes to UDC that are not specific to the UDC changes will not be permitted. This includes general statements, attacks to the intent or character of staff, or statements about processes, policy, or other items that are not specific to the Unified Development Code. Changes discussed in the UDC will not automatically be incorporated into the UDC. Further assessment by staff is required, and the legal team regarding how changes may impact operations, and the legality of any requested changes will be required. Staff will not entertain suggestions that potentially violate state or federal law. This meeting has a fixed time to adjourn at 5 p.m. However, I will determine the adjournment time and any breaks based on the need and any finishing of business. Do I have any additional questions based off of those rules of order? All right, we will move along. So first, the next item on our agenda is an overview of the Unified Development Code process by Senior Planner Ben Rhoads.
Thank you. Thank you, Kris. So all of you at the table, and we also have this online, is a calendar that gives the layout of what we're doing. This has evolved over time based off of different inputs that we've been received as a staff, as where the community is wanting the more options to provide feedback or not. But any case, as you can see, we're about halfway through the process. This started roughly October of last year with the first versions being made available for review. We did that at an internal level last fall, and then finally kind of did the debut to the public of draft 3.0. That was, we received public comments on that. We did have a open house, kind of not really a workshop, but just like an open house on the code on February 27th, where we did receive some public input. From that, we made version 3.1 based off of some inputs that we received. And I did understand there were some questions about what was changed and why and whatnot. We have a document that I prepared. That's a new document that hasn't been seen yet, but basically giving you bullets of versions 3.1, 3.2, and what was changed, as well as the reference guide number. So there's a 48-page reference guide that goes through every change of ID number, so you can refer back to that. I found that with such a large code, it can get very cumbersome very quickly with so many different changes and citations and such. So it's referring back to those reference guides are very helpful to say, I'm curious about this specific thing. But as you know, we wanted to engage the stakeholders. And so anyone in the audience, a stakeholder is essentially a person who in their profession will use these codes and has vested interests in them and for development in general in the city. And so stakeholders were identified as anyone who has done development projects, I believe, within the last 2 years. Megan assembled a list, and we emailed out to everyone we knew of and provided a questionnaire that had references back to version 3.1, which was made public. And we had had comments open on that for about 3 months, going from early March and ending just the end of May. Then we did a workshop. This is one of 2 workshops with the City Board of Directors. That was on May 20th. And as you can see on the calendar, there's check marks for what's been accomplished, and then the boxes are where we are going in the process. So today, June 9th, being the Stakeholder Roundtable. So we are in the process. So 3.2 has been pretty much set at this point. What I'm hoping to do is to come up with version 3.3, which would be the future version that will reflect any additional changes from this point forward, so that we're clear what versionings we're doing. So we will take whatever input we receive today, put that in version 3.3. There will also be a town hall meeting that's open just for the general public. If anyone wants any further questions about the code, that will be on June the 24th. from 5:30 to 6:30 in this room, I believe, yep. And then while this is all going on in the background, we do want to have one-on-one meetings also with any stakeholder who wants to meet with us individually, or meetings with board members if there's a desire to meet on the revisions of 3.32 and then eventually 3.3. We will then follow with another workshop. This is the second workshop on July 17th. That's not on a regular meeting night, but I believe that's on a Thursday, if I recall correctly, but that's July 17th. And then after that, we'll take any final inputs and then get that ready to go to the Planning Commission in August. And then going through regular procedure, that will go to the Board of Directors. And then we are projecting October 7th as the final reading for the ordinance. Now, of course, this can change. This is not written in stone, so if there's a need to table something or whatnot, we can amend the calendar as needed. And that basically gives an overview where we are in the process. I did want to transition to specifically some of the comments and kind of how we're going to work on that today. So may I do that? Or
I'll go ahead and speak to that. So the way that this portion is going to work with the next item on our agenda is to review the stakeholders' comments and city staff responses. We're going to begin with just an overview of all the different comments. We're going to go through just a slide to show what those comments were. So we know that some of those stakeholders are not present, but we did want to make sure that the public had an opportunity to see some of those comments, and we're going to go through those first. Then I'm going to revisit those with some of the city responses and why we may not have addressed some of those issues. To my right, our city attorney representative, Heather Owens, has joined us, and she will be assisting with questions if they come up. So we'll go ahead and start with Ben. He'll do the presentation, and then after that, we'll go through the questions and comments. I'll go through them one at a time, and that'll be an opportunity for the stakeholders to jump in.
So what we did to try to be possible with this is to take the comments that we received and put them in a spreadsheet. And this is not the full spreadsheet. I'll go over here. So we have the number when we received it, the person, if there's a guide reference, and then the version that was commenting on, and then what the comment was, and then our response to the comment. And then there's some additional stuff over here, but that's not really relevant for today. So just generally, we've organized these by when they were received. So you'll see like these all came in from one individual. That's because I think that those comments were the first ones we officially received. And then like this one here, love that you can do an ADU on a lot. That was from the actual public meeting. We had comment cards, and so that was written on one of the comments. It was the only one we received at the meeting that was written down. And then we had some additional ones that had came in. You'll see also these are from staff as well. Some of them are, it's called ARC legislature. That means that there was not a formal comment to our code, but there were new laws being proposed. As some of you that have followed the process very closely would notice that we put it on pause for a little bit because there were outstanding legislation that was coming out of Little Rock that would impact the code. And so we wanted to make sure that this is reflective of the most current laws and that nothing was inadvertently being put in here that we weren't allowed to do, essentially. So that's what those were referring to. And then we had this one, comments have come in, were through an email that this gentleman was not actually able to come today, but we can briefly go over some of that. And then some final comments that came in from the survey, the ones that say survey on there were taken or paraphrased as best as possible from the survey that we received online, and just kind of summarizing some of those comments. We're not going to go through all of these. We'd be here an hour, had to read through all this, but just wanted to kind of give you guys sort of a overview of what the comments were, and go from there. So is that? So moving on to the agenda, we want to open it up for comments from the stakeholders.
I'll go ahead and
Okay.
I'll break these down.
Okay, good.
So again, I won't be addressing every comment that's on there. For example, if it says good change 10% to 15%, that's noted, but that by itself would not be something that we stop to discuss. So one of the comments that came from Jim Caldwell was to consider adding statement, quote, exemption, easements created by a plat only will be allowed to be relocated with an updated plat as long as the relocated easement is of an equal or larger area, and that utility providers have verified that there are no utilities in the existing easement that is moved, end quote. Explore with city attorney on wording that meets the state statutes. So just as a background on this, we have previously worked on this with the first Jay Williams that was with the city, and then we had an additional city attorney, Jay Williams, and now we have a new city attorney, which is
Harrington Miller.
Miller.
I'll be here most of the time.
So we have reviewed our current process with each of those entities, and they all agree that the current process that we have meets the city's statute the state statute for cities of the first class. So the state law determines a process for vacating an easement in ACA 14-199-103. The requirements appear to be more specific to cities of the first and second class rather than the process for the county, which is more clearly defined in ACA 1869-01. While relocating an easement is allowed contingent on the requirements defined in ACA 1811-704, the only process defined for a city of the first class to achieve the relocation is through the vacating of the existing location or a portion of the existing location and then dedicating the new location. This was reviewed once again by our new city attorney, and our current process does appear to be compliant with the state statute. To change it to the recommended would be compliant. It appears to be compliant with the county portion of the statute, but it is unclear in the state statute the process for the relocation and how that would work. Therefore, the erring on the side of caution, it was recommended that we maintain our current process for relocating easements. Jim.
Thanks. Yeah, I appreciate you sending me the state statute 704, and maybe the attorney can help clarify that. To me, when I read that, it's a separate statute than the closing statute, but it just says for relocating, we can create a statute for relocating an easement. And I think you've even got somebody here in the audience that I've got a project that we're just finishing up on, utility easement. He had to send over 40 letters out. And to me, they have no interest in that easement. These 40 people in this neighborhood, the utility companies certainly do, which we verify and certify they don't have anything in there, and the two neighbors. But again, I'd like to see if we could revisit that as well, because I think there's, as you mentioned to me the other day, many attorneys could get different opinions on this, and the fact that the state created a separate citation for relocation seems to indicate to me that we shouldn't have to follow the other one and go through all this 2.5-month process when we're trying to move a lot line. So.
The distinction here is between just a regular easement and a utility easement. And state law specifically provides the means for relocating a utility easement, and you have to do it in accordance with the statute. The statute says shall. That doesn't give us any discretion to do it any other way.
Yeah.
If it was just a regular easement, like for egress, you know, to someone's house that's landlocked or something like that, that's different. But utilities are treated differently, and we have to follow
Yeah.
what's prescribed in the statute.
Well, again, it seems that, yeah, a regular easement for egress does affect the neighbors and all the people around them, whereas a utility easement, the only people that it affects the stake are the utility companies themselves, so.
I hear your complaint.
Uh-huh.
It's probably valid,
Uh-huh.
but we still have to follow the
Well-
statute, what the state legislature has told us we have to do, and that's what it says.
Yeah.
And for the stakeholders present, if you look in your packet that was provided, you'll see a copy of each of those statutes. And again, just to make sure that was clear on the recording, this is being recorded. The state statutes being referenced are ACA 14-199-103, ACA subsection 18-60-901, and ACA subsection 18-11-704. Typically, the Title 14 items would apply to cities of the first class, second class. There are some additional considerations to look at in ACA 1811-704, which provides that criteria for the relocation of the easement. And that's where the dispute is, and that's what we can
Right.
we can look at that, but ultimately the city attorney is our legal representation.
Sure, I respect that. Again, I think the 103 is vacating a public utility easement, and all I'm saying is for relocating a public utility easement, let's do it on a plat. We create them with a plat, let's move them with a plat, so.
Yes, sir. Did any staff have any additional input?
Yeah, what we did as far as the Unified Development Code, why this is coming up, is we created a specific process in our code to close right-of-ways and easements. We have a process for a lot split, a process for, significant development permit, all the different things. We don't actually have anything in our codes, our local ordinance, that address how to go about doing it. We had a policy from 2009, I believe, but nothing in code, so we decided to put that in our codes to be specific on, how to, the wheres and hows and all that. So it's consistent with the other sections. So, Megan, did you have anything you want to add?
All right, so we'll just keep moving along. And the next item is along that same lines, and it has the same response. It was also, consider adding a statement to an additional portion of the code, which is for lot line adjustments. The previous one was for lot consolidation, but it's the same request, and it still falls under that same response because the next comment was for a different type of project, but for the same process, which is requesting to consider adding a statement for an exception of easements created by a plat only will be allowed to be relocated with an updated plat, et cetera. And that's that same response from the previous item would apply to that as well.
Yeah, I'd like
Yes,
to hear
sir.
from the other, Ron and Clint, if you weigh in on that. Well,
I was looking something else up. Exactly what am I weighing in on here?
well, just this.
Easement relocation.
We're relocating easements with a plat that were created by a plat. And my concern is, as Ben said, we're going to codify it now in our city code. When it's not right now, let's leave it at the state law and let that be negotiated as the years go by, as we get different attorneys. And that's what I'm concerned about, is locking it into the code, that we have to do this in 2.5 months.
Well, I guess I'm going to answer that question with another question for the attorney.
Can you pull the microphone a little bit closer?
Sure. So if it is added to the city code and then state legislature later changes it, the state law would take precedent over city code, correct?
Yes, we would need to revise ordinances.
But-
But that happens everywhere all the time.
Yeah.
Which-
I just, I would prefer it not be in there like Mr. Caldwell, but I understand that state law would overrule it at whatever point it changed.
Just to be clear, the process in here we're talking about is this the process of how to close any type of easement. It's not to say what you're talking about relocating is a different issue. This is to say, if you have an alleyway, what do you do? What's step 1, step 2, step 3? It's not going to lock in a, whether you can shift them or that type of thing. That's a separate issue.
And I would actually correct that statement. The alleyway is a public right-of-way, and it goes through a different vacation process. But I would state, yes, what you're speaking about is easements in general, which can include utility easements or other types of easements, versus an alleyway is typically a public right-of-way. Yes, Mr. James?
A utility easement is a utility easement regardless of where it's located geographically. I guess this is for the attorney. Why does the state law dictate a difference between, your Class 1, Class 2, and the county? Because it's still a utility easement.
I don't know why they do that, but they do. So how that came about that way, I don't know.
I didn't know if there was, I didn't know if there was a reasoning, if there was.
I don't know the rationale for that.
Okay.
But easements outside of the city limits can be treated differently than easements in utility.
Yes.
And if you don't mind, since we have quite a few people in the audience, I can go ahead and read 199-103, which is the vacation of public utility easements, Part A. States cities of the first and second class and incorporated towns are given the power and authority to vacate public utility easements or segments thereof within such cities and towns under the conditions and in the manner provided for the vacation of streets and alleys by subsection 14301-301 to 306. Part B, a petition requesting the vacation of a public utility easement signed by the property owners through whose property the easement extends shall be filed with the municipal legislative body and dealt with in the manner provided by law. And I'll just stop there. I think that's the gist of the difference in the county. Whenever you look at the petition to vacate process for the county, it states in 1860-901 that the owners of realty that is encumbered by a public utility easement and located outside the boundaries of any city or town may petition the county court to vacate the public utility easement. The petition shall clearly describe the easement. And while it does describe a similar process, the way that it's typically done, and Jim or Gene, you can probably correct me whenever I mess this up. In the county, it gets platted with a legal description, and whenever you relocate it, you just are doing a single plat that vacates either a portion of that or a full easement, and then you are showing a new location where that would be on the same plat. It gets approved by the county and gets filed for record. However, in the city, you have to go through a petition to vacate. It goes to the board of directors to vacate that easement, and then it has to be dedicated separately on a plat. So it does add some additional time, and I understand the frustration because it is a little bit longer of a process.
Even though it's the same thing. The
And
end
I
result
think,
is
well,
the
but I
same.
think the rationale is probably state law gives cities much more authority to regulate planning and development within the city limits. Counties don't have those same restrictions or the ability to regulate as much as cities do, and that's probably, again, this is just my educated guess, but that's probably why that the process is different when you're inside a city.
Yeah, just finalize it, I think my hang-up is just the wording. We're actually not vacating this easement, we're moving it. So I wouldn't say we're vacating it. And you're applying the law to vacate on a
There's
relocation.
no law for relocating.
I know,
inside the-
and that's
And
why,
I think that's why.
You're right.
When I had this discussion, there's no,
Mechanism.
there's nothing, no case law.
Right, exactly.
Interpreting this statute.
Right.
I can only say, based on what I'm reading, my advice to the city is to follow the statute it could lead to issues
Well-
later if we don't.
Again, I would just follow the relocate easement statute of the state, which would mean we could create a UDC code for Siloam to follow it in a different way. Notify the neighbors, do it in one reading. We could create a code today to meet state statute 704 on relocating easements. That's my suggestion, so. Yeah.
All right, do we have any last comments on this issue?
Clint. I guess just well, the way the wording of the legal code is, does it says a municipal legislative body, does that have to be in a public forum?
Yes.
Okay, does that have to be public notification? Okay. It's out of my wheelhouse, so just thought I'd try and help.
All right, if we don't have any additional comments on this, we'll move on to the next item. So the next comment was also from Jim Caldwell, and it states, relative to annexation, it says further explanation on who pays for conditions upon terms, costs associated with extending infrastructure to the proposed annexation area. The staff did not take action on this or add it because we do believe that the payment is dependent upon the conditions, and I will deflect to Ben Rhoads if you have any additional comments on that.
Yeah, I mean, those are, I think with an annexation, typically what's happening is that's land that's coming in because a developer has acquired that property and they are seeking, some type of city utilities for, is coming in. And so the term of who pays for what, it would generally fall along standard platting procedures. The developer puts in the infrastructure, the streets, the water lines, sewer lines, and then they dedicate that to the city with the final plat, and then the city agrees to maintain all that infrastructure into the future. I think that's what you were asking. I'm not quite, I don't know if I quite understand the full comment, so.
Well, again, it's how much of the on-site, how much of the off-site infrastructure to get to these places. That was the question I had. It wasn't clear to me who pays for it. But.
And I think that's where, on some of these developments, it's just a matter of, on a case-by-case basis, to look at what specifically is being referred to for those conditions. I can think of lots of different things that may come up during and I'm not familiar with this specific section that was being referenced.
I can read it here.
But if Ben, you can pull that up and read that, please.
Luckily, you put the citations there, so thank you for that. It makes it much easier. So 3551C, which is on page 55 of the redaction, says annexations may be conditioned upon terms reasonably necessary to avoid any substantial burden on economic, physical, environmental, or civil resources of the city, including without limitations the costs of annexation, costs of expending public infrastructure and utilities, costs of public facilities, right-of-ways, and open spaces, and annexations may be conditioned upon terms reasonably necessary to protect present and future land uses. So I think it's stating essentially that when an annexation comes in, we as a city have the right to provide necessary conditions if there was an exaction of costs onto the public. Like say there's an annexation and we required to build a new road to the land, and that would be a public road. We would then request that there would be a cost share or something to that. But it's really on a case-by-case basis. It's not the state that's going to happen every time. This gives more of the ability for the city to act in certain situations. Kris, you want to add on to that?
So if it's my understanding, what Ben is saying is this is, it may not be applicable with every project that is with an annexation, but it does give us the opportunity to collect those on a case-by-case basis, depending on what that item is, whether it's an improvement to infrastructure or utility, different things like that. And that would fall under the exactions. There's not a lot of things that, if there's even anything, that the city's board of directors has more authority over than annexations. So they can do a pretty significant amount of considerations that are attached to an annexation, conditions of approval. And the only thing that may come to mind that's even close to the amount of authority that the board has on that is rezoning. However, rezoning, you can't put any conditions of approval on, which probably makes it a horrible example. But with the annexation, though, this isn't saying that we're going to do that every time. It's just allowing us to do those exactions as needed.
And also at the very bottom, you'll see a rubric. It's in blue. And the blue rubrics are just, they're not codified. It's just explaining things. I know it can get confusing, but that's saying that that section was just copied from another section of the code. So it's nothing new
Right.
or proposed. It's just being reorganized and put here. So.
Right, which is now's the time to, let's see if that still needs to be in there, so. Thanks.
So if I don't have any additional comments on that, make sure I did not miss anything. The next item is based off of appeals. It says that on page 58, Title 3, Article 3, Section 35-56A for appeals. This section does not specify where an appeal from a Board of Adjustment decision is to be directed. Add this information. So to answer this question, you have to understand what the role of a Board of Adjustment is. A Board of Adjustment is your local judicial branch that makes judicial decisions. Therefore, an appeal of a Board of Adjustment always goes to the applicable court, unless it's otherwise specified in the code. And I can have our legal team kind of weigh in on that, but my response on this was maybe it does need to clarify where it's going, just so people have that route forward. So I wrote, as a response to this, that the Board of Adjustment decisions are mostly judicial decisions and appeal to the court. We are looking into language to further with the new city attorney, as of right now, to determine if we need to call out the court by name and where that appeal route would go forward to. Ben, did you have additional?
I do. In version 3.2, the section saying appeal to a court of record having jurisdiction, that phrase was added. Of course, that's brand new. It needs to be checked by our attorney, but it is the most recent attempt to respond to that comment.
And I would ask our legal if they had any additional input.
No, we can look, I mean, I can.
Okay. All right, did anyone have any additional input on that?
Thanks.
Sure. The next comment was, how will the city manage to enforce park maintenance in subdivisions that don't have a POA? This is in reference to page 18, or 118, excuse me, Title 6, Article 2, Section 35-105D Parks. And I believe, if my memory serves me correctly, that's relative to parkland dedication. So what, if you had a new subdivision, then this is the idea that with a new subdivision, that you would dedicate a portion of that as parkland or potentially pay a fee in lieu. Did we add that portion?
We did.
Or pay a fee in lieu. And the question was, how would the city manage to enforce the maintenance of that park? So that goes to, these parks are common property of the POA. So your average POA life is not forever. Mm-hmm. So the question I think that I'm hearing is, what happens after that POA goes defunct? And this is an enforcement question. It's not necessarily a legislative type of a question. So I'm not sure if we have a lot to change, but it does ask the question of enforcement. So, and it's similar to a detention pond. So if you have a detention pond that's owned by the subdivision and it is if the POA goes defunct and they stop maintaining that, then that would typically, from a staff point of view, go to our legal team to determine if that could still be charged to the individual property owners that are still obligated to maintain that. And we're still looking into that, because that is something that does happen whenever you have these type of common properties, but that's not relative to parks. That's relative to any common property that's in any homeowners association. Yes, Mr. James.
On those parks, why doesn't the city, since it's dedicated to the city, why doesn't the city just accept them as part of city property? You know, because I know some of these detention ponds will have hardware in them, you know, for drainage and things that, you know, why are they left as POA or?
Sure, on the common properties.
Yep.
And that's something with the detention ponds, we're looking at those for, we are looking at those for in the future whenever we have a drainage criteria manual update. That's not a part of the UDC.
Okay.
However, that is definitely something that's come up is moving forward, how do we want to address these? Because from the development side, it's services that portion of the development's drainage issue. It mitigates the issue caused by this development. So from the city standpoint, you know, it's theirs to maintain. But from a practicality standpoint, theirs to maintain eventually goes away. So we do run into that in my profession a lot more than you would think, where the POA is gone and this is a common property. What's the appropriate action? Usually those fall under an LLC or an incorporated type of an ownership, and those lapse. So what we end up usually doing is identifying who the known representative was at the last time and contact them. I've been doing this for about 20 years now almost, and I've never had one where I haven't been able to somehow get back to someone that was able to resolve the issue.
I was just
But
curious.
it is a topic that can be challenging, but that's something that we would also address in the future for those detention ponds.
With the
Yes.
parks as well, why don't the parks just be dedicated to the city as city property?
That's definitely something I'll ask staff to write that down so we can send that to the board as a recommendation from our stakeholders to see how they feel about additional parkland dedication that would go to the city. I know in some cities that it would go to a board, for example, a Parks Advisory Board. We do have one of those. And it would determine whether or not the city would be the receiver of that type of thing. So there's processes that we could mimic in other locations that are successful, and we could present that potentially to our board.
Because depending on the size of the property, you know, if you got a park of fairly, you know, good size acreage in it, that's a lot of tax at the end of the year for something that, you know, that the city, that you're required to dedicate to the city, but you know, it's not yours. You have to maintain it and pay maintenance costs and everything, but just a thought.
I definitely understand that. Does anybody else have any additional input on that?
Well, the Winding Springs coming up tomorrow at P&Z, there's a park area, right? Will that be privately maintained?
Private.
At this point, the code supports that any of those would be privately maintained. We don't have a mechanism to move it forward during the development process to be publicly dedicated. Is that correct?
Yeah, that's correct. We're treating these as basically POA, private, like Ravenwood, you know, how they have their privately maintained areas. It's pretty much like that. Now, we can look at city dedicated parks, but like Kris was saying, we really need to talk about that with the Parks Department, because they only have so much resources to, you know, maintain what we have. So I think Ron has a comment.
Mr. Holmeyer.
Are we can you clarify for me again, who all gets to use these parks? Is it just the POA members, or is it going to be a general public park?
If it's private by the homeowners association, then they have the ability to restrict the access to that with their covenants.
Okay.
If it's dedicated to the city, then it's ex facto a public park. Only restrictions can be from the board of directors.
I was just making sure we weren't expecting POAs to make their private property available to the general public because of the liability that they would be assuming by that taking place.
That's correct. There is basic tort immunity for any entity for parkland dedication and use, but that is limited to the same components as a city, which is gross negligence. The problem with that is if you have a POA that goes defunct, then whose responsibility is it to continually maintain those? And it's kind of a circular reference. We're back at the beginning of the conversation with that. So, but that is a good conversation, and I know that there's going to be some board members that want to have that conversation and how to address that. And maybe it stays. There's other ideas that I've heard in the past, like maybe it stays with the POA for a certain period of time, and then it gets dedicated to the city. And we can definitely look into that. So, any additional comments from staff?
I would be curious, just Ron, if you had any comments in particular, not about that section, but just 35105 in general, because it is a very big change compared to what we've been doing. But we tried to be very fair with not requiring it for subdivisions that are 25 lots or less. It's really kicks in, well, actually 25 to 49 would then be the size of a single, like a pocket park, one single family lot. And then once you get over 50, then you're basically kind of proportionally increasing based off of the size of the subdivision because you're having more and more lots. But this was something that had come up multiple times from different sources of saying we need a mechanism for more parks in our community. So anyway, just wanted to see if you had thoughts on it.
I have mixed emotions on that item, and I haven't really had a chance to discuss it with some of my clients. So at this point, I'm not going to say whether I'm particularly in favor of it or opposed to it, because I really don't have an opinion yet.
Okay.
With no additional comments on that, we'll move to the next item. So there was some additional comments that I believe that these comments were made before we brought some items for the sidewalks. We did make, I think that we had received some comments and have gone through and made code changes separately from the UDC because our board members wanted to address some issues a little bit faster than we could throughout the whole UDC process. And I think that that's where some of these sidewalk conversations come from. Yes, Ben.
So particularly on 35114D, which was on the easements, we did receive a comment and we did make changes on that. So it's greatly simplified compared to what it was before. So, and it does include the historic district, which you asked for. So.
Yeah, I appreciate that very much. The one question I had was the very last sentence there. We've done a great job in clearing that up, moving that back to the 8 foot required by the landowner. We can't impose extra easements because there's not an easement on the other guy's land next door. But you've got item 4 at the very end. It says greater easements may be required if specified by the city or private utilities. I don't see how we can leave that in there as we've now clarified the whole rest of the section and just leave that open-ended without any sort of guard for the citizen that you guys could decide, well, I need 20 feet. It just seems simple to me. We fixed the numbers on the code. We need to strike line 4. And if the city needed a greater easement, they could go through the process of buying the easement and all that. This doesn't limit that, but I hate to see us leave in open-ended statements like that that don't give us any assurance that we're in the right. So
Right. So some of our past projects, Danny or Johnny has requested additional easement widths for their utilities if they find that they need those additional easement widths. So that code has come in handy when we need it. Now that's on a case-by-case basis. But do you have a specific, was there a time, I can't think of a time where that was a problem ever with a project over the last 2.5 years that we had.
Well,
Do you?
that's my whole point. I don't, yeah, I think that can be negotiated without having this codified to say, if you need it, you can have it. I just don't think that's fits with what we just fixed.
Well,
About
one
there.
problem that if we took out for entirely,
Uh-huh.
they would have no authority at all to get a greater one. Even if we needed it, we would have to, I guess, apply for a variance or a
Right.
waiver or something in order to get relief from the existing code to allow for a greater easement, which could create a real encumbrance on landowners that are just trying to split their property. And now they have to go through a whole variance process because nothing in the code says they can get a wider easement.
Yeah, and like I was saying, I can think of several occasions, you know, on a case-by-case basis where this code has assisted staff, electric department, and water staff where they need those additional easement widths. This code has backed them up so that they can provide that comment. We just get that taken care of on the survey at the time of review. But without this code, we wouldn't have that to back us up. But I can't think of a circumstance where this ever was a problem for the applicant or for you guys to revise it. So it just seems like keeping that in the code has been beneficial to us, whereas I don't see a benefit in removing it.
Well,
That actually may fall under the city's allowance for exactions. So one of the things I'm going to talk with the attorney about is this code even this portion of the code even necessary? Because we still have the ability to do exactions. If we're not specifying the amount of that, it's questionable whether or not we can, if we're not specifying a specific amount, whether or not it's any different if we specify the and more or an unknown amount in the code, or if it just falls under the state statute, if there's any difference in that. So we can take that into consideration. I'll have staff put a pin in that one, and we're going to send that to legal for an additional review.
yeah, again, because the rationale for making the changes on the first part of the section was, and I've been told this a lot, the neighboring property doesn't have an easement, so we need more on your side than's required, and you've come back and we've fixed that. But then you finished the whole section with item 4 that says, well, if we need a greater one, so what's to stop them from saying, well, there's not one on the other side, so we need to make it wider on yours, and we're gonna,
So I guess my question is, would your suggestion be to, I mean, like a compromise, I guess, instead of removing it completely, putting a maximum on that to be the maximum?
no, I think
match
it's
this?
handled with another, the city can get an easement if they need to, not the landowner, so, anyway. Good. Great, thank you.
Chris, I'm gonna go ahead and
Yes, sir.
stick my toe in this one. I've had this come up on many projects, and it hasn't been an issue. We've been able to work it out where we gave extra easements. But what I don't want to see this turn into is where one of the franchise utilities, or all of them, decide, oh, we don't have enough easement, and we want the entire setback, front, rear, whatever,
Right.
for easement. And then the property owner buys a house, and they can't do anything in their backyard because it's all easement. They can't do anything in the front yard because it's all easement. Okay,
Like my backyard. And
that's my concern.
Right.
so, thank you. Do I have any additional comments from the stakeholders? Do I have any additional comments from staff? Staff, please take notes on that to get that to our legal department for review with any applicable notes for that. We're going to go ahead and move forward. Get back into the conversation about sidewalks. I'm not going to touch on those a lot because I think that we brought the sidewalk issue forward, but did you have any, Jim, did you have any additional comments on sidewalks while we're on that topic?
Yes, I don't believe the code version that you've just published has the correct wording. And it was confusing because we had several ordinances and then we revised it on the second and third reading. And I think you're still on the first reading, and I've got the copy of the,
Okay, so you think that just our current version of the UDC doesn't have?
Yeah, that might just be a copy error, and we can get that fixed. So
yeah,
that's
because
fine. Yep.
the way it's
Thank you.
written, we're going back to putting it related to the master sidewalk.
I
plan and
had
all
a
that stuff.
version that Kevin had sent me, and I put it in the UDC really early on.
Yeah.
And I think what happened is I didn't go back and change it because it got changed halfway through the process. So.
And that's one of the reasons why we try to limit our single-page text amendments on codes where we do those smaller codes, because it's when we have different versions of the UDC going forward, then, but we appreciate you bringing that to our attention, and we'll make sure that that gets updated. Do you have anything else on sidewalks while we're on that topic?
No.
Did anyone else have any additional, stakeholders or staff have any comments or questions on sidewalks? Okay, we're going to move forward. The next item is relative to enforcement. This takes us to page 155, Title 7, Article 6, Section 35-168B, Enforcement. The request was to add a statement that says, however, private citizens and developers will be granted the same accommodations that are given to city departments when they are allowed to make improvements that are less than those required by Title VII street design standards. This is particularly relevant with, that's end quote, excuse me. This is particularly relevant with regards to the dedication of right-of-way and areas that street improvements have already been made, and there are no plans at the present for their upgrades. Also, this change was presented to the Board of Directors, PZ, and city staff at the August 23rd, 2023 Town Hall meeting. I think that this was the very last thing that I talked to Kevin about before he left, our previous city engineer, and he stated to me that this was already addressed in the previous code revision, that he had brought this forward as a single item that allows the city engineer more autonomy to make decisions to allow it to be addressed at the city engineer level. And if he were to fail changes that you had requested, if you had made a request to him, and he were to deny those changes, that there was an appeal method that allowed you to move forward to the Board of Directors. Does that sound familiar?
It does, and yeah, I checked back, and the last year or so, I've done 28 projects on collector streets.
Yes.
Well, 2/3 of those have been on collector streets, and repeatedly we have to keep dedicating a 70-foot right-of-way, and my point was on that, we can show clearly the city has improved a lot of collector streets in this town, Kenwood Street and others. They've not gotten the full right-of-way. I just think it's fair to the private citizens that I do a lot of work for to not keep having to dedicate right-of-way, especially for streets that have already been improved recently or repaved. And that was the rationale for that statement. It may be tough to enforce, I get it legally, but we need some work. And this is related to the next item with the master street plan, that before we codify that has to be updated. There's way too many collector streets. I've been told for several years that we're going to update it, It's still not updated.
And one of the things that, language matters in all of this. So one of the things that we're trying to move from is standard street sections to typical street sections. So the big difference in a standard to a typical is just because it states typical, it's a little bit less, the wording is a little bit less strict and allows us to move back into a direction where you would have a little bit more leeway. But I know that we're having that conversation, just what you were referencing, the master street plan is going to move forward separately. And that will be the actual street classification plan. Now, this typical street sections, I believe, are a part of the UDC, and they're part of this plan. Those were designed by Kevin before he left. And Ben, can you share where that's located?
On the redaction, it's page 157 through 159. He just did two of them, street cross sections, and then street cross sections for overlays. So they're different options. So we're not locked into one, but he did them kind of all on one sheet here with individual options for the different street classes. So you can look at that, and if you have comments, we'll get to that to the new engineer. So
yeah, again, I'm not too concerned about the street width. That usually gets in the civil guy, but we get into a lot about the right-of-way dedications and giving up, which affects the buildability of a lot. The recent one on Britt Street had to give up right-of-way and it almost nixed the project because it shrunk the buildable area. And the street, we've already overlaid it, and I asked Kevin before he left, he said it'll be over 20 years before we ever widen that, and yet we keep having to dedicate the street width over. So, yeah, you mentioned there's an appeal process, but what do we do is for our clients when they decide they want the 70 feet, and I have one that's getting reviewed today. I should have some comments on it, actually.
And I think the goal of the appeal process, when that went through, was to allow the expedited process, because previous to that code amendment, the city engineer didn't have the autonomy to make those changes. It just said if you wanted to change from what he interpreted it as meaning, then you had to go through the board of directors. And now he can interpret it. It's a little bit less strict. He or she, the city engineer, can interpret it based off of their review, and if it does or doesn't meet those requirements, then he or she could deny that if it deviates from that. And my understanding is that if they do deny that, then that's where you would follow the previous process, which is take it to the board, and the board would have to make a determination. Gene?
So what we're saying with this here, all the collector streets are going to be just a straightforward 70-foot right-of-way?
That's was it?
Because previously it was like 52 to 72 feet. You know, there was a range of right-of-way in there. And I was just curious as to what or who determines what the actual right-of-way is going to be for a given collector street.
Yeah, he's going to pull it up on the
Okay.
screen so the audience can also see.
That's page 155, right?
Because I honestly get so confused with that when I'm trying to look it up. I'll turn in one right away, then it's like, oh no, well, this is a collector street, it's going to be this. Well,
One moment here. This is the old one. So here is the proposed first option, and then the second option of overlay that's going away at the red line. Second option of overlays is here. I can try.
That's the navigation.
Was there a particular one that you wanted to look at?
Collector.
the collector. Because the old one, it read, it said 52 to 70 feet. And
This is
it
the
would-
one for overlays that have the two side paths. We can do a standard one that's up here. So here is the standard one, yeah.
It looks like they're both 70 feet, yes.
Okay, so that's what it, okay. That answered my question, thank you.
Maybe I asked Megan's staff, how did that get evaluated on the job coming out today? Help our conversation. Yeah, yeah,
Turn your microphone on.
okay,
Tonight.
okay. But again, yeah, there's so many collectors on our master street plan that are driving this right-of-way conversation, so that was the impetus of that enforcement statement, but it's also tied to the right-of-way dedication requirements.
So is your concern that you just want a little bit of flexibility based off of where it's located, or is it the 70 foot in
Yes.
general?
Yes, and now I believe Garver is now our dedicated
Carver's
review.
currently our contract city engineer, that's correct.
Okay, and I spoke with them in the fall when they were here in this room. They talked about Kenwood Street, and that's a mile of collector, and yet it's only, a quarter of it is only 70 foot wide, and the rest of it's less. And I asked them the question, each of the engineers, why is that? Why?
Maybe that's something we need to look at. What do we have built for our collectors on average, and compare it to what we have versus where we want to be, and
Yeah.
And see if it is time to make a change from that 70 foot, because I know exactly what you're talking about on some of these.
Yeah, the one
'Cause-
tomorrow, Winding Springs is only 60,
Yeah.
and it's a major collector.
And I
And
think
I
the
can
other
let
person that
Garver know
knows.
to look at your minor subdivision as an example for that conversation.
I think another person that weighs in on this topic a lot is Ron, because he does
Yeah, me
a
again.
lot of engineering in the city. So, Ron, do you have some input?
Yeah, obviously I've been doing this a while in this town, and I remember when collectors were only 60 feet right away. And now that we've moved to the side path trend of today, that suddenly jumped to 70 feet. I think in the older part of towns, the city has been very reluctant, for whatever the reason, to go through and actually purchase the 70-foot right-of-way when they do street projects. I think Jim and I both have seen that through the years. And all he's asking is, in the older parts of town specifically, I mean, greenfields are a different story, because it's,
Right.
but when you're in an existing part of town where there's existing streets, existing right-of-ways, and existing development, there needs to be some kind of a compromise. And I'm not going to throw out specific numbers. I have some ideas in my mind, but at the same time, I just think staff probably should look at something for the existing conditions that's different and more reasonable than what they're expecting in the greenfield developments.
And just for clarity purposes, the previous right-of-way was also 70 feet. So we weren't upping it. This is existing, so this is current code. This goes back to at least 2005. I don't know, maybe even before then. Ron,
And
you
it's-
might remember when we adopted that. It's a while back, but.
It goes back that far.
Right.
What we can definitely do, though, is take a note of that. We're going to see if we can have a conversation with our contract city engineer and see if there's potentially even a note or some sort of a boundary determination for these areas that are built environments versus greenfield environments. So if we have an area of town that's not going to experience dedication needs for a period of time, then maybe we can identify those areas where we could deviate from the typical collector and find a solution that would be more appropriate to a pedestrian friendly area that wouldn't need as much of a right of way. And maybe that's specific to just portions of town. I'm not sure how that would look like, but maybe we can get with Ron and a couple of you guys, and we can talk about identifying some of the areas where we find these problems the most. So
You do that on your master street plan.
that would probably be, my guess is what that would probably look like is we would have to have some sort of change to the collector typical street section. And then we would identify those separately on the master street plan, yes. The master street plan itself is, however, we're not going to be making changes to that during the UDC process because that by itself is going to need a pretty extensive review process. So what we are doing during this UDC process is currently in our today form of the code. The master street plan is all of the text document and the map. So what we're doing is we're splitting the text out, and it's going into its own chapter.
Street design standards is the new
Street
title. Yeah.
It'll be the title for street design standards, and when we talk about the master street plan after the UDC is adopted, if we say master street plan, we're just talking about the street classification plan. That has been a confusing topic to try to explain to people for years here, I believe, and I think that by clearly dividing them, we can bring this topic of the street classification map and bring that forward to an updated master street plan in the future, and I think that would just require a single-page text amendment if we did need to change some of the typical street sections to accompany some of those changes.
Do you have a timeline on when we can update this?
It'll be typically when you have larger changes to this type of a map, it'll ultimately be up to the board and the city administrator when we start moving forward on that. But typically they like to have if there's a vacancy in the city engineer position, then they would not like to move forward until we get a city engineer in place that would just be the representative for the project all the way forward. So my guess is our current contract with Garver ends on August the 31st. Try to remember how many days are in August. So we would probably identify after the UDC, if we still have Garver for a longer period, then we would probably need to work with their services for this. But if we get directive from the board that we want to still pursue the city engineer, it's really going to ultimately be up to them whether or not they want it to go to the third party or to the or wait for the staff engineer to be hired.
Well, again, I'll speak to my engineer friends. I don't think it'd be that difficult to go through and eliminate a number of these collectors that are in the old part of town that are driving a lot of this problem. It doesn't seem,
correct.
but I've been told for several years we're going to get this updated, and it's still.
I know Kevin had started the process right before he left, so it did not make it to the light, but hopefully he has some information that started the process that we can push forward to the next engineer or to the third party. Any additional comments related to street design, typical street sections, or the limited conversation of the master street plan? Okay, staff? Anything? No. Okay, I'm going to move forward. Where was I? 15? That was, 15 is relative to the master street plan. We included that. 16, parking standards. Page 195, Title 8, Article 5, Section 35-216F. A comment from Jim Caldwell. This is the last comment that we have from Jim Caldwell to address today. Eliminate this requirement for requiring bicycle racks. Leave this as an option for the developer. The response is that this request essentially is just asking us to remove this from the code, which does not support the city's expansion of bicycle usage and needs similar to parking. By asking to make something optional implies that if it is not in the code, then it would not be allowed. This ensures that there are safe areas to park bicycles for those that use this form of transportation, just like parking areas for cars. So essentially, if you make anything optional in the code, then it'll rarely, if ever, get built. Also, it's already optional if it's not in code. I think that that's the point. If it's not codified, then it's optional in the development either way. So the question on this was, are requiring bicycle racks something that the city's board of directors wants to have to support the bicycle infrastructure that we're building out throughout the city, and ultimately that'll be up to them. As for now, staff didn't take any action, but the board does have a copy of this statement, and all of the ones that are marked green today, the board has received a copy of these with staff's recommendations. So, do I have any additional comments on that? I think that there's probably occasionally some different optional things for different that come up in conversation, like and some of it is how many streetlights do you need? How many trees along public rights of way do you need? And to some people, that's not, some of these things are not that important. Some people it is important, but what I try to look back to is what are some of the things the city's doing? The city is building more trails and bike connectivity, and this allows, if you utilize that trail, to have a place to attach to have your bike just like a parking lot.
Yeah. One thing I would add is that as public servants working in city government, we have to represent all the citizens, and some citizens do not have cars. They actually have bikes because they can't afford a motor vehicle. And so this is just thinking about them, where if they go to a restaurant, they might want to have a place to lock up their bike while they're eating. So just something to think about.
Have any comments from stakeholders? All right, any additional comments on that from staff? All right, no more comments, we'll move right along. We're going to move to some of the questions, comments, and suggestions from Jesse Fulcher with Calera. I will pretend like I said that right. So the first one was, why does the definition of property line adjustment only limit to 2 lots? That was something that we went through and fixed. Some of his are a little bit more simplified questions, so it's probably faster if I just go through those. This was something that we added some additional language to do some clarification. It had stated 2 lots. We added or more. Pocket neighborhood is ambiguous. Consider units and acreage limits instead. So, Ben, did you have any additional comments on that one? Pocket neighborhoods is one of the things that staff has been talking about a little bit more and how we would address those. So I think that might merit a bit of a conversation for pocket neighborhoods. I think there's lots of different names for pocket neighborhoods, but most people just know them as pocket neighborhoods.
I believe we do define that in our codes because it's not actually a new concept. It came in a few years back. There was a development that the late Mr. Ron Drake was working on north of town that used the pocket neighborhood concept. And so because of that, we were wanting to include something in our codes about that. And I believe we have a definition, but I don't have it right in front of me. But if I find it, I will certainly relay that to the group. So,
Is that synonymous with a cluster housing?
I just have a question too.
Go ahead.
I believe cluster housing and pocket neighborhoods are both discussed in our 2040 comprehensive plan as well.
Okay.
So that might be part of the reason for the definition.
Okay. While Ben's looking at that, did any of the stakeholders have any comments regarding that? Okay. So we'll move along. Townhome definition, why limit this to only 3 units? Ben?
we were trying to provide sort of a concise definition, and let me find that too, so it'd be better if I could read that before I comment on it. So let me look at that. Okay. Oh, we added it.
So while he's looking that up, one of the things we also did was when we were looking at definitions of certain things like buildings, structures, you may have noticed there's some changes that aligned with some other things. Like Randall Clark is our senior building inspector. So we did get with him and we tried to align some of these definitions with our International Building Code. And that's where some of these changes that appear throughout the code have come from other areas, because when we're bringing a unified development code together, we may have things defined differently in each individual title. Then you bring them together and you have words that have different definitions for the same word in the same title. So when you have different titles through a code, you should theoretically have already solved that problem by aligning your definitions. But whenever you have a new singular code, you have to do that because you can't have multiple definitions. So we had to go through, and the smartest way of doing that is align it with the International Building Code. So, Randall, did you have any input on that? I can't let him sit over there too quiet.
Well, the building code just defines townhouses 3 or more single-family dwelling units contained within one structure. So, yeah, we
Less
definitely
limiting,
need to
limited.
read what we got for the definition of there and make it align.
I know what I'm going to do here. I'm going to do this. See if I can find it.
You find it?
Did you?
Townhouse?
Yeah.
Just before section 35.3.
35.3. Oh,
Okay. Oh, it's under the use units.
that's what I said.
Okay.
Well, this one I'm looking at says townhouse means a building that contains 3 or more attached dwelling units, which is exactly what you just said.
Yes, and just while he's looking that up, that's why I brought up the International Building Code, because I do recall that we did change that to align with the International Building Code. So, Ben, we can circle back to that. We're going to keep moving forward. Did anyone have any additional questions on townhome definition?
It was
Okay.
townhouse. Here we have it. Means a building contains 3 or more attached units. So the reason
Your microphone's off.
the reason that it's 3 or more is that would be considered, if it's 2, it would just be a duplex. So it's 3 or more. It's not limited to just 3. So
Yeah.
Sorry,
there's
sidebar.
confusion in the comment because he's saying it's limiting to 3. It's not. So I don't know why he's getting that.
So it does say or more, so
Yeah.
it does look like that comment was probably a moot point. Next up, questions why section 35-45C4 is needed. It either meets zoning or it doesn't. Can you pull up 35-45C4?
Okay, so what's this? Oh, okay, that's C, right?
The property line adjustment will not substantially damage the value of the neighboring properties and.
So I see the concern with this. The property line adjustment will not substantially damage the value of neighboring properties. So I'm not sure that's wording that can be utilized to justify an approval or a denial. So we need to put a tack in that, and we'll send that to legal. That's correct. Well, that's why,
That's existing code.
even though it's existing code, sometimes when we go through these reviews, we need to identify areas that need to be adjusted.
No,
So
that's
let's
true.
go ahead and put a tack in that, and we will send that to legal. Only 2 more pages. Next up, questioning why there should be a short expiration on lot splits. Ben?
I believe I did have a response on that in the spreadsheet, so I'm going to go ahead and pull that up here. See Mr. Fulcher's comments. I think it's this one here. It said, explained and then asked the question why 60 days is too short the file. So I asked that. I've been waiting a follow-up from the applicant. I did send him an email on that, but we weren't clear what the problem was. So this is 60-day limit to file. So it's already been approved. Everything's signed, sealed, and delivered, and then we didn't think more than 2 months was too much to ask to just take it up to the courthouse and file it for record. And usually it's you're wanting early filing and you want to get it done and official. You normally is a waiting period after the process. But I would defer to the surveyors. I mean, would that typically happen? Or, you know?
Well, I would think anything that's staff reviewed should have a 1-year limit. The county, I'm doing a job and things happen with the buyer and seller and things change, so it's just on hold. And it's a staff review. They're fine. They don't have any issue leaving the permit open. It's just a matter of process to get it finally filed. To have them start over after 60 days for a staff reviewed seems a bit extreme.
So I'll speak to that a little bit. The other thing with the 60 days is that that's typically how long a code amendment would take. So if we get a submittal, we're reviewing it underneath the current code. Let's say that we're working on a code amendment that may impact that submittal in some way, at any point in time. Then 60 days is enough time for them to file that prior to that code amendment going into effect if there is a code amendment. So that 60 days is just one thing. The other thing is, I will say I worked for the city of Tawnytown, and they did not have a limit on that. And that was something that I struggled with frequently as the planner in Tawnytown, was people waiting and bringing me a plat to sign 7 months later after I've already reviewed it. And I can't even remember this plat. So just trying to get those taken care of and get that cleaned off our plate and make sure that things are getting done in an appropriate amount of time.
Ron?
Correct me if I'm wrong, but this is after staff has signed off on it and approved it, that we're talking
Yeah.
about 60 days to record it.
Right.
And I do know that there can be complications on closings, and so closing, a lot of times these are recorded at closing, and so the 60-day limitation could be an issue in instances. So I agree with Jim or Jesse, that could be, in some circumstances, an issue.
And, one of the sidebars I was just having with legal was whether or not our county counterparts, whenever we give our signature for it to go to be filed, is there any enforceability on this on our end? Because they can file at any time thereafter with the county. We don't accept, we just sign off, and after our signature is done, it moves to the county. What's the enforcement action?
We
if they
require
did
that they
with-
give us the filing number. So the project's not closed out. The city clerk doesn't sign the application until I have a filing number on the application.
And if that's filed with the county at day 61,
I'm typically flexible as long as they're making good efforts to file it with the county.
okay, if it's filed on day 180. You see, the issue is we're not the enforcement agent on when it gets filed after we sign off. They can take it to the county as long as they meet the county's requirements. So one thing that I need to have legal look at is, at this point, are we now doing an enforcement action on something that is a county item? Because the filing portion, I don't know if we have any ability to say, hey, after day 60, you're out of compliance, because that gets that filing stamp on it from the county, not from us. Do you understand where I'm coming from?
I am.
Does that make sense, Gene?
Megan, after, you said the 60 days and you're possibly going to change the code in the meantime, say you wait, 180 days or whatever, shouldn't the fact that you've already signed off and approved it go ahead and cover it, like grandfathered in, even if you change the code after that fact?
Well, and I consider that a good faith effort to go and take it and file it. You brought it to me with your property owner signature, with the surveyor signature, and I've worked with you guys in multiple occasions where that's happened.
Yeah.
But that's a good faith effort. You guys have come to me, you've provided it to me. I'm talking about circumstances where they wait 7 months later for me to come and sign this plat. I don't think that's.
got you.
Yeah.
Okay.
So if my signature's on it and you're taking it to the
And
county.
they hadn't filed it yet, okay.
Yeah, good faith effort. I've had certain, occasions where you haven't given me that filing number. I've gone and hunted it down myself, but that's fine as long as I can find it. If they're waiting more than 60 days to bring me the plat with the property owner signature and the surveyor signature, that's where I would have a concern.
Ben?
The only thing that I just want to bear to mind is, you can find surveys from 20 years ago that been signed and maybe never got filed, and now you're taking it to the county and filing it, and it could be completely different, or not meeting current standards. Setbacks are different, easements are different, and so without having any guardrails at all, there's really nothing preventing something like that from happening. That's the only thing I would be really,
But
maybe
is-
not 60 days, but could we say 180 days or a year, or could we come up with a different date, for instance?
But even 20 years later, does it change the fact on anything? If you guys had already signed it and everything, and they just waited, 20 years, wait, that we found this in the safe, we didn't file it, let's go file it for record. It's got everybody's signatures, even though everything's completely changed, it shouldn't change the fact of anything that was agreed upon.
Well, I'll give you a case in point example. There was a city in Oklahoma, I think it was in Broken Arrow, I don't remember specifically, but they had a mobile home park that was approved in the 1980s. It was never built. And the developer, someone bought that and said, well, these plans are still good. They were approved in 1984 or whatever, and they went ahead and legally were able to build this trailer park, even though everything around it was completely different, did not match the current land use maps for that area. And so our attorney has said, well, we need to have expirations on some approvals, that they don't just go indefinitely forever, because things do change. And so that's something to think about.
And I understand that too, and it's like your old town lots that were done in the 1900s, you know, those have no setbacks on them. You know, that comes back to a building, you know, your building requirements. You know, if you say, okay, we're not gonna let you build on that, you know, but there was no imposed setbacks or easements on any of those lots. It's kind of the similar thing, but just, that's all I had on it.
And we are gonna send that to legal for additional review on that also. And so I think one of the things that we need to note on there is the 60 days. Okay, the next one is question on ownership and maintenance. If a public or private park, I think that was the same one that we talked about earlier. I don't think we need to readdress that. The next one was, why are there specific easement widths required? I can say partially on a minimum easement widths are required because you have to have maintenance widths for equipment. If you're doing work just from the city, for example, then we have to do all that work within the easement boundary. You go outside of the easement boundaries and you cause damage, then the city or entity is responsible for those damages. And within those easement boundaries, they have a little bit more flexibility. For example, if someone puts something in the easement that's not supposed to be there and it's damaged, then as long as the work was completed within that easement, then there's a lot more flexibility associated with that. Did any staff have any additional input?
I can just add that I actually got a phone call from a citizen last week who was asking about a private franchise utility going into her backyard and asking what her easement width was. And when I looked at it, it was an older plat, and the easement width was only 5 foot, and that was not big enough for their equipment to get through. So that's something that they had to work through last week. But that's part of the reason for our easement widths is for the size of the equipment. They didn't have enough for their equipment to go in there and actually stay within their area.
One thing I would add is for a long time when I first started working for the city, we didn't have codified subdivision regulations. They were from like the 1990s or something. I don't remember. They weren't in our code. So one of my jobs was to actually adopt or create Chapter 87, which is now the subdivision regulations. And so we got all the utilities together. I remember this meeting exactly, but we got all the utilities, the franchise utilities, and everybody in one room and said, okay, easements, what do you guys need? And we went all the way around because they're utility easements, so this is what they're going to be using. And so we went around the room and we came up with a reasonable amount of width that was good for those utilities based off of their spacing requirements. So you can't, lay them right on top of each other. They have to be spaced out. And so that's basically been what's in the code ever since. Now, of course, it can be changed, but, it was not planning that came up with that. That was all the utilities. So.
In the interest of time, we have about 55 minutes left, and we still have quite a bit to go through. I'm going to just go through these really quickly and see if any immediately stands out on the comments, because the remaining comments are from stakeholders that are not present. It does appear that we've addressed the majority of the ones that I think we were mostly concerned with. James Surveying did have a comment that said, define to us precisely how these rules benefit the public, make it and to make it make sense to the general public, I believe. I think that that's one of the things that we're trying to accomplish with the general public input sessions. So I think that we're doing that now. One thing to note is I think that what we tried to do with this is listen to people's additional calls for public input. This may be the most public input for any item that's been through Siloam Springs processes. So anybody that says differently, I challenge you to bring that forward to me, because we still have an additional 6 rounds of public input to go through, including a town hall meeting, the joint board workshop, planning commission, and then 3 rounds with the board of directors. So we're trying to fit in as much public input and stakeholder communications as possible. Stakeholders will also have an additional one-on-one time with staff that I believe you may have already been emailed about. And you will, each of the board members will get one-on-one time with the staff so they can address any specific detailed concerns that they may have from additional notes after these meetings. So from that, I think just in the interest of time to make sure that we are moving forward, I'm going to go ahead and do we need a break? Anybody? Okay. I didn't need one. So we're going to go ahead and open it to stakeholder Q&A, and if you want, I can just go. He says you go first. No. Sorry. Ron, did I miss some from you? Where was that?
I think both these guys
Yep.
questions.
Yeah, you had a.
Oh, they just got pushed to the bottom. I apologize.
Yeah.
So,
They were the last comments received, so they're at the very bottom of the list. That's why. Yeah, these are H, and I think these are.
let's go ahead
Yeah,
and
we can just go through these one by one. Yeah.
staff should be empowered to do their jobs in reference to modification of plans. So one of the things that we are in the process of looking at is some of the board members have been looking for opportunities to provide staff autonomy on certain decisions. I can't say that that's from all board members, but I can say that there are some board members that are already exploring that. I don't think that it would be appropriate for staff to try to expand their autonomy in a request that's coming from staff, so I think that that would need to come from board members.
That was from me, and it was more just in general to the line item where there's like a 10% amount of change that could be done without going to the board, and it went to 15.
Yep.
But it doesn't define things. You know, there are small things that can change numbers. Like I think I thought like if they have 7 dumpsters on a big project and they go to 6, that exceeds the 15%. So now it has to go to the board. Why does that need to go to the board? Why couldn't that just go through staff?
So, and I believe I took forward the code amendment for
Yeah, this
the
has been
modification. So that was already something that went before the board of
2513.
directors.
Oh, that's correct. We actually did that as a separate item. We expanded it from 10%. Did we expand it from 10 to 15%?
So we increased
10,
it from
yeah.
10 to 15% and also extended the timeline for it because it was only 1 year after approval. So we extended it through certificate of occupancy issuance to allow for changes, throughout the construction process and stuff. I think it was a little more flexible language on the factors for it as well, because we understood that we had the dumpster enclosure at one of our projects that triggered a 10% change. So we understood that, and I think that was something that was revised in the language of that ordinance as well. But that was taken care of separately a few months
And I
ago.
will point out that that was at the request of a board member specifically, so that's where that item originated from, was from a board member that had requested staff prepare an ordinance that moved it forward to the board, and it was under the previous city administrator's administration. He did prepare and bring that forward, and I believe that was approved in February-ish.
I think it was March that it was approved, but it was approved.
And if
February, March.
you go to page 43 of the Unified Development Code, the section in green is to say that that's past ordinances that have recently changed. So that's what was approved. So.
All right, just in the interest of time, we have about 50 minutes left, so let's go ahead and go to the next item, please.
Let's see, landscaping costs will be more expensive.
That was just to ask, how would this change your project? I said, that's all. That's
Yeah,
all.
that was these are survey responses, so it was kind of, we just had to put them in there as best we could, so, yeah.
So what's the question?
I think one of the things that staff was questioning on that was, did you have something specific that was in there
No,
that
they
was
just
going
asked
to,
how it would impact the project.
or is it just generally?
Just
you said
generally,
if
yeah.
The RDOT right-of-way doesn't allow trees, then you have to move them. And
Okay, I see what you're saying.
It's just a general
Where you
remark, 'cause
have
it asked me a question, so I answered it.
Just so the people in the audience know, a lot of RDOT rights-of-way do not allow trees to be planted in the RDOT right-of-way. For a city to have trees planted in the RDOT right-of-way, typically that city has to, for that section of street, has to sign an agreement to maintain. However, the UDC is bypassing this by allowing the proposal is to have a 5-foot easement, I believe, attached to the right-of-way that would have a a landscape easement where the trees would still be planted if RDOT denies them. Does that sound correct?
We had a section in there on that, but I think it's in 3567 C3. Yeah, it says all streets, any street which is denied within RDOT right-of-way shall be planted in the center of the 5-foot wide landscape easement adjacent to the RDOT right-of-way.
And that shouldn't increase any cost because those trees are required already. It's just saying, hey, if you can't put them in the right of way, you need to put them somewhere else in a designated area for that. But that's already a requirement of any significant development project.
Yeah, it's fine. I think my comment was more into regard to a few different things, but it's not a big issue. I don't think that's gonna be a problem.
Okay. Next.
Indicated multiple contacts and concerns, but desires to meet in person with staff. This is various. Oh, I'm sorry, I skipped down one, didn't I? Issue with neighborhood meetings. And again, these were paraphrased. That's not exactly what you put in the survey, but try to get it to fit on the spreadsheets.
Yeah, you're fine. This is a new condition y'all have added where project has more than 30 lots or something like 25, 30 lots, something like that, that the applicant is required to meet with the neighbors before applying. I've talked to several clients and I haven't had a single positive response. Most of them were very strong negatives about that concept. That there's a lot of issues in that when you have a meeting here, in addition to proper recording, proper notifications and all that, there's also security. So, you know, you're asking these applicants to go into a hostile environment with no security and just a lot of issues with that. And I think that really needs to be looked into a little further before it's just thrown in there.
I think that's also something we probably need to look at with legal. I do know I worked for the city of Conway at one point, and for some of their projects, the city mediates meetings that has a specific time where the developer stands on one side and the general public goes through the microphone one at a time. And
I like the term mediate because that's important.
Yes. But I do see where you're saying if you do have a large group of upset citizens, there could be some issues associated with requiring our requirement for you to schedule that with them on your own time, and we need to look at that from yes, Ben.
So this came out actually from the former community development director, but also just observations that what happens in the public meetings, sometimes it's not as cohesive as it could be, where, we're having side conversations between developers and landowners or homeowners trying to answer questions and do negotiations kind of like during the public meeting, it ends up being very heated, and a lot of it adds a lot of time onto the process. And I think a lot of it is the idea of it is it will give more of a face-to-face time with homeowners that might have a question about a fence or a berm or a tree or how their house is going to be impacted with the developer, and allow the developer to potentially pivot and plan so they're not already in the final approval process where it's difficult to make changes because you're already in the approval process. That way we're not kind of locked in and citizens are feeling like, well, they don't have any influence other than just requesting that the planning commission or the city board vote down the entire project. And it just seems to me that might be a good opportunity to allow just positive, constructive dialogue between the different parties involved. That's all.
It sounds to me like the process, it's not the idea that you have a problem with, it's the general process of having the potential of having potential angry public versus developer in an alone setting.
I understand the comments from because I read those somewhere, that those were the justifications for the extra meetings and all. And yes, the process is a big part of the concern, but at the same time, I spent almost 7 years on Benton County Planning Board, and when people tried to have silent conversations, that was shut off. There was a public hearing time, people got to comment. They could not address anyone, the applicant or anybody else. They were required to address the board. If they didn't, they were removed, which didn't have to happen, but they were told that was what was going to happen. And then the applicant was able to come back up and address the comments. And if they missed any, the planning board would remind them of anything else. And so the interaction, the questions were answered, but it was done in a civil, organized way. And I'm just afraid of meetings on private property without somebody to mediate or control the situation. Not saying it will always get the way, but it has the potential to get ugly.
Yeah.
And yeah, we're going to look at that with our city attorney's office and try to figure out a way that would be more appropriate. So,
Well, I
yes, sir.
follow up with that too. I think, again, there's nothing to prevent these conversations from happening prior to application. I think the heartburn I have, again, is codifying this, requiring this extra step and meetings, and let folks do it as they want prior to application, as they see fit. Don't add a section to the code for that. So.
Okay. We'll take that down as a note also.
I will say in the last 2.5 years I've been here, I've only had one applicant take it upon themselves to do a neighborhood meeting prior to submittal. And that was actually one of my projects that were submitted this month.
And,
Yeah.
you know, it's,
They just don't do it. That's what the problem is.
I definitely understand some of the concerns from Ron, was having been the individual that was tasked with being the mediator in Conway. 99% of them, nobody shows up. But that one had 350 people present, and with me and a gavel at the front of the room. So
You understand.
it's like,
that.
while it's not a lot, me with a gavel at the front of the room was able to provide some sort of order. And also, we were able to anticipate that, to have the appropriate security personnel present. So, yeah, that's definitely something we need to look at.
I agree.
So, can we go to the next?
Just kind of sum up the rest of them, because they're just all real general. I have a few extra comments that are more specific. I just, at the time, didn't make the time to try and type them all out. So, yeah, I do feel that I'm not seeing anything that jumps out at me as that we're going to speed up this process. I'm not seeing anything that jumps out at me that's going to help reduce costs, because, the right-of-ways are same or bigger, the street widths are the same or bigger, lot sizes are the same or bigger. Plan development, you now have the added expense if you go over 25 or 30 lots of a rear entry residential, and that is an expense, especially when you're doing 16-footer alley pavement in a 30-foot right-of-way. And I do feel like we need more time, even though we got the delay because of the legislature. I still do not want to see this go through in just a couple of months.
Okay. So that concludes Ron's comments. Were there any additional comments from any of our stakeholders? And then we can go ahead and do the next portion of it, which is the stakeholders Q&A. If you have any additional questions from stakeholders to staff, or would like to talk about a specific portion that has not already been addressed, I'll go through one at a time, and we will allow you an opportunity to have at it. Jim.
Thank you. On my electronic version, I did have number 17 that I don't think was up there, which was fine. But the comment was, one, please distribute the community development procedure policies, which we requested since February, and a board have asked for it as well.
And I will point back to the stakeholder roundtable rules of order. We won't be talking about policy today.
I know, not specific policies. I'm just summarizing my point that I submitted back in February. And just that in order to solidify this code in this process, we really need to look at our community development manual and the processes to implement this code, because so many of those affect what's written in the code. And I get it, that's not what today's about. I'm not going to talk about any specific procedure, but we've got to address that in some sort of timeline along while we do this as well.
And I think that there's, I know that you've been given different responses over the last year. You know, I've had an opportunity to look at what the different department level policies are in place. And all I'll say about policy is the items that are legislative in nature, we're going through that and we're having our city attorney look at those, and we're trying to invalidate anything that should not be in policy. So it is, I don't know the extent of where it's at right now with our city attorney's office, or if it has been resubmitted to them. But I don't know if it was with our previous city attorney. We just got a new city attorney, if you don't know. But I can tell you that I have reviewed that, and I can, if you want to come to my office, I can pull them up one at a time. We can take a look at the ones that we have, but I don't see a lot that's being enforced that would be legislative in nature. There have been some policies that were carryover from previous administrations, and we have had recent conversations that if it's not either the current or the previous city administrator, where it hasn't just been updated by our interim yet, then some of the older ones should be moot point. We have, if there's something that has David Cameron's name on it at the bottom of it, then it shouldn't be valid, because it's been years since David Cameron was the city administrator, for example.
2 points. First of all, I think I just want to clear the air about the policies. I think there's a lot of confusion about that. There are no internal planning policies that the planning division follows. It doesn't exist. So when we get a policy, it's coming from the city administrator's office. So only the city administrator is saying, do this or do that, but they're not legislative. They're simply how to go about to follow the city codes. Now, the development procedures manual is just a checklist. It's not rules. It is, I mean, you can challenge anything in there. It's just telling you how to do something. You know, a lot of this is Greek to people. They don't understand what a setback is. They don't understand how to go about to apply for a lot split. That's what the procedures manual is. So don't read it like it's city code. And I think that would be helpful too, just to keep in mind that, yes, we will update it from time to time, but it's based off of, when we have new personnel, we want to have the right phone number on there and things like that. So it's not so much, a regulatory piece. The regulatory piece is the city codes. So.
Okay. Well, again, it's tied back to a permit I just submitted in January 2nd, talking about other documents and other plans that we followed the checklist, but it wasn't, we had to do an extra item. So anyway, I just think those conversations will be helpful as we work through this code to make sure that we clarify that, and we don't have things in these other policies that don't match this new code.
James.
If the planning department is not dictating policy, you're saying it's coming from the city administration, where's the city administration getting it from?
So when we have a new policy, which doesn't happen very often, it's like, first of all, I think that there's this confusion of what city department level policy is. I just wrote the other one the other day to clarify the dress code. That's in community development. That's a community development policy. It's also a citywide policy now because the city administrator liked it and expanded it to the whole city. There's a few that shouldn't have been in there. Like there's a policy that says by policy you should have a foundation for a light pole that's made out of concrete. That's not a policy item. That's something that should be in legislative text. So we are sending those. These exist throughout the city through different departments. And the previous city administrator had sent those to the previous city attorney to review. And I don't know where that left off, but I won't go further into that conversation. But any of our policies that are at a department level should be how staff is interpreting the code. And it does originate from the department head typically and gets signed off on by the city administrator. If the city administrator thinks it's something that affects all departments, he or she can make that effective citywide. The city policy is part of our employee handbook as an extension of our employee handbook. So it is enforceable. So if we have, for example, our dress code, if that goes into policy, staff is required to follow that just the same as the handbook. Yes, Megan.
I think a good example of a policy that we just did is the in-home family child care businesses.
Correct.
In which we wrote a policy so that staff could understand when to do a business in-home occupation business license and when they were a commercial business based on state statute. And so it's not legislative, it's just telling us what the appropriate route is based on what is legislative.
No, those are because that's a complex issue. It doesn't sound like a complex issue, but when you look at the state statute as it was currently written and passed about 2 years ago for in-home child care services versus you look at what the fire code says about in-home child care services versus daycare, and then they reference each other back and forth, it's very easy to have a different interpretation every time you look at it. So the idea is to have a policy in place and saying, we're not going to reinterpret this every time we look at it. We're going to have this interpretation. It's going to be reviewed by our legal team. And the legal team is going to review that to make sure, hey, this already exists in law. This is either exists in ordinance, state law, federal law. And this is how staff is going to interpret these state laws to make sure that we're staying in compliance and not being capricious and arbitrary. As long as we look at this policy over the same way each time, then it's less likely that we're going to have a different interpretation and deny someone that's asking for the same thing and getting a different result. So,
especially when we have different planners coming and going, those things change.
and each one of those is going to be slightly different, but that's the gist of it. Is policy is just there to interpret the ordinance consistently. So. I will move forward on that. Did you have any additional follow-ups?
Well, pass it up. I just echo what Ron said. This has been a really helpful meeting. It's been 90-some days since we first gave the comments. Now we're getting feedback, but we're ramped up into this. The P&Z is going to get it next month and all that. So it seems to me like a reasonable target by the end of the year to get this approved by the city board and allow some more conversations. So I want to hear feedback on what the response was on some of these issues before it goes any further. It'd be very helpful. So thank you.
Mr. James.
I have no, any questions or anything. I just one-on-one meeting would be, probably better, just discuss some of the planning procedures, just the regulations. Has nothing to do with this meeting. It's policy more or less. But yeah, like Jim said, this has been very helpful, very insightful. So I appreciate everybody taking the time to make it happen.
Thank you. Mr. Carstetter.
Yeah, I'm just thankful that y'all bringing people into it and getting everybody's opinions and feedback to get the policy as streamlined as it can be.
All right. Thank you, Mr. Holmeyer.
Meeting has been useful and helpful, and had I turned all these in, you would have needed much more than 2 hours. But a couple of quick things, and it's just because it's recent. Lighting design, photometric. where does that fall? Because it seems like that should be in the UDC.
So the photometric is underneath parking area design.
Okay, so I missed it then.
I don't know if that, and like I said on the phone the other day, I don't know if that's in UDC. Is it?
I'll get you the citation, 1 second.
And just so everyone's aware, what Ron is talking about is we had a project that was not meeting the foot candles. They were exceeding the foot candles, but we talked to him about the street lights and had determined that street lights do not apply to the photometric. So if it's for health and human safety, then they can remove that from the photometric plan.
So photometric plan is only because of parking areas?
Yes.
Interesting.
I doubt that's exactly accurate. I need to look into that because there are things like apartment complexes have building structural lights. And I believe that those photometric plans have to display that the appropriate bleed off onto the neighboring properties meets requirements, even if it's on structural lights. So I don't think it's just applicable to parking lot lights. And if it is, then that's something that staff
I
needs.
believe, yes, like for a building permit, yes, but that's not part of the planning review, or I mean, in terms of the large scale review, what we're looking at is when we're doing the planning reviews, 35217A does say 5 or more shall be continuously lit at night unless administrator determines that the parking area is not used by daytime business hours. Exterior parking lot lighting shall be directed toward the ground, shielded, full cutoff style with no lighting or glare exceeding 0.5 foot candles measured at 5 feet above the grade may intrude beyond the property line.
Is that separate in our building code or?
No, it's within
Randall?
this.
So if we have an apartment complex and it has a big mongoose light on the back of the building and it's facing towards the neighboring property, are you telling me right now that we don't currently have that in the UDC to regulate that?
What I'm telling you is the UDC covers parking area design for
Okay.
photometrics and does not mention structures, lighting on structures. Now, when they provide their photometric plans to us for review, for example, Ron provided a photometric plan to me for review. He included the street lights for the driveway that was shared between the two properties. And that is not something that is considered part of the parking area design. So he was allowed to remove that and meet the foot candles.
That's I would
So
agree
we do
with
need
that.
to, I think what needs to be pointed out is we need to identify, thank you, Ron. We need to identify where we can have some limitations on other lighting that would be at the location to ensure that we're protecting the rights of the neighboring property owners from new developments from bleed-off lighting.
Well, obviously, I looked in the wrong place, but at the same time, a previous issue came up where we had a little bit too much light on the right-of-way of the road, and I had to get an adjustment done because I was exceeding 0.5 at the street right-of-way.
I'm not sure if
So
adjustment's the right word. It was removed, was it not?
So this, when you start diving into it, looking at what really applies. Because the last one in particular, yes, the neighborhood, the residential behind need to be protected. And commercial to the north, commercial to the south is not going to know the difference between a half-foot candle or 5-foot candles at their property line, or the street right away either, particularly in this case because of the light pollution from the neighbor across the main road there. But anyway, if we could focus that for rear and side only, if it's adjacent to residential, and not this just carte blanche, every property line can't exceed 0.5.
And I think we have another project that was kind of going through the process right now, and it's two adjacent similar uses that is a connected parking lot.
Well, that's Ron's
Is that the one
project
that
that
he
we
was
were
talking
talking
about?
about.
Okay.
Yes, yeah.
And I
One
changed
thing-
the interpretation, the intent of that code. I can interpret that a little bit differently because of that intersection right there. It has that joint, where there's a joint driveway. I was able to interpret that as not being applicable. Yes,
Right.
Ben?
So,
One thing I will say is I think part of this, what we're seeing is how different staff people review things differently, and you might see that with tech review comments where I say something, but how I look at this is it's only the proposed. You're not looking at the ambient lighting whatsoever. You're just looking at what's lights being produced by the proposed lighting.
Right.
Does that exceed 0.5 at the foot count? So if there's a street light, you're not looking at the street light, you're not looking at anything else.
And I get that, but I think the original intent is to protect residential properties from excessive light pollution. And when you just automatically say every property line can't exceed some random number, which this is, 0.5 is just a random number picked out of the air, then you're not really fulfilling the intent. You're just making it harder on the developer to get the lighting he needs on his property while not exceeding lighting on the roadside or next to another commercial property that's putting off 5 times or 10 times more light than his is producing.
Yeah, I would agree. I mean, part of it also is sort of it's not just residential, it's sort of the dark sky in general, of trying to, and cities are doing that, of trying to, and when you can, reduce some of the glare and shine up of lights, particularly if they go around further out on the edge of the property where, quite honestly, you wouldn't need to light your neighbor's property if the intent is to light the parking lot. So that was sort of the broader concept of it.
Okay, for just a matter of time, I do have an opportunity for the public to provide input. Ron, did you have any additional input? I want to thank the stakeholders before I move to the public input portion of this. We appreciate the work that you guys put in for the city, and we appreciate the work that you guys have put in for this project. It may not always agree and see eye to eye on every component, but I think we all have the same goal, which is to provide good products and try to make the city of Siloam Springs a better place to live, work, and play. I do think that a part of that is to have a strong connection with our public and the public input. We will have another town hall meeting. If you're not given an opportunity to speak today, we only have 25 minutes, and I'm not going to use up more than one of them. On June the 24th, 2025, just one last time, 5:30 to 6:30 p.m. in this room, we will have a Q&A public forum. After a quick, Megan will be giving a quick review of the overall project. So we have added that at the request of some of the citizens and board members. For today, if I don't have any additional comments from staff or from the stakeholders, I will move to open mic. Do we have an IT member present? Do we have? All right, if you want to come up to the microphone, you have an opportunity. If we could try to keep it in about 3 minutes, that way if there's other people that have anything else, or we'll also have time to respond to any questions that you may have. If you could also just state your name and address just for the record, that way we have that on the record. Okay, anyone? All right, I also want to thank some of our, go ahead.
Rebecca Wyatt, 1109 East Jewel Street. Now, I haven't asked any of you, and I should have done that before, but I wanted to ask about the new kind of mother-in-law dwellings, and how will that impact how many people will live in the city?
Sure. I can start by saying that we refer to those as accessory dwelling units. Just one thing to note is accessory dwelling units by state law will be required by right in any residential single-family district. If you have a zoning district that allows single-family, Ben, correct me if I'm wrong, if you have any zoning district that allows single-family uses, if that land is used for single-family uses, then an accessory dwelling unit will be allowed by right. But yes, that does make it where those single-family dwelling areas would be eligible to have accessory dwelling units. The city will have limited enforcement on what those look like. The state has adopted similar requirements to single-family residential, so we no longer have the ability to say what those accessory dwelling units look like or any of the key components to those. I believe that we will have, I'll let Ben speak on it because we may be waiting for the accessory dwelling unit ordinance to change with the UDC, just because we don't get a lot of those.
Right. To answer your question, so we don't really address accessory dwelling units at all in our code now. And we had a section here, this is the section, Unit 3, where we had already proposed to address this. But because state code preempted the city, or they just kind of got there first, we are having to make a few little amendments here. That's what's in the green, is to comply with the state code, because they go into specifics as to how big these can be, the percentage of the lot. You know, we had some stuff about matching building materials, architectural styles. We can't do any of that. We have to take that all out. And so this has been updated to comply with the state requirements. But essentially, the state and the city were heading to the same destination on the train. They just, two trains just got there at the same time. But everybody in the housing world is screaming ADUs. We need them. You need to allow them. And so that's what we're doing. So,
Can I do one more question?
Yes, ma'am.
Okay. Let's see here. On the bicycle racks, would that mean that, like any business that's in existence right now, would they be required to add a bicycle rack to their business?
No.
But just the new businesses
yes,
would have to?
just new.
It's a development requirement, so whenever you have a new development, then it would be a requirement with the new development. Anything that doesn't have one, if it doesn't have one because it wasn't required to have one, then those would be in compliance because they would be grandfathered in from the requirement.
Are they expensive?
They can range in costs, but usually it's not a tremendous expense for a singular bicycle rack.
It'd just be a single?
It depends. Do you know our requirements for
Yeah,
those?
I'll pull that up, Ralph, 1 second.
Thank you for answering.
It was 4, I believe, yeah.
4 for all size development, or is that?
It just says four, accommodate four
Says
bicycles.
4?
is what
So it doesn't
says.
grow with the size of the business?
Oh, one bicycle.
No, I don't think I don't think we were just said they need
When
to
I
have
worked
a
in
bike
Rogers, we
rack,
had a
yeah.
business that required, I think, 36. So we had to deviate from that, so.
Yeah, this section of code says for commercial, office, institutional, or retail buildings requiring vehicular parking shall install a bicycle parking rack to accommodate no less than 4 bicycles. So it could be 200 spaces or 15.
So it'd be 2 of the loops.
It doesn't matter. It just has to have one. Yeah.
Okay? Yes, sir.
Kent Wyatt, 1109 East Jewel Street. Since we got the time, I just wanted to say I know you guys went to a lot of trouble to make this happen today. I see it all, everything that you've done, everything, and I just really appreciate what you all have gone through to get to this place to help everybody kind of understand what's going on and what it all involves and everything, and I just appreciate your work. Thanks.
Thank you. All right. Anyone else? I also wanted to thank our board members for being here in the audience today. We have some snacks over here on this bar, and anything that doesn't get eaten or taken will be in my office. So, and my wife doesn't appreciate that. So please feel free to get yourself a drink, get yourself a snack, take something with you. And at this time, I don't think we have anything else on the agenda. Do I have any additional comments from my staff?
I just wanted to thank everybody for making the time to come out here. Your feedback's been invaluable for the process. It makes for a better code, and thank you for that. And we look forward to meeting with you one-on-one, anyone who wants to do that. So thanks.
Okay. Any additional comments? No additional comments. I will adjourn. The current time is 4:44 p.m. There's no vote required because we are not that type of a body.